The urgent application for the interim interdict was filed by 2 NGOs and 2 sports fishing clubs. The groups argued that the exploration activities Shell applied for were unlawful and affected parties were not given an opportunity to appeal the exploration right. Questions around environmental damage were also raised. Shell argued that all approvals are in order for it to continue, and delaying the project now will amount to huge financial losses for them. The company also says that there is no evidence that the surveys affect marine life negatively, as is demonstrated by the vast number of similar surveys that have been conducted over the past 5 years around the globe. The application was dismissed with costs. We're now joined by Melissa Groenink, Program Manager for Natural Justice. A very good day to you, Melissa. Thanks for making the time. The case has been dismissed. Your response?
Thanks for having us here today. We're obviously very disappointed. It's an unfortunate outcome, particularly considering that the judge did not recognize the urgency of this interdict, despite finding that there was urgency, but what that immediate threat to the environment that is posed by these seismic surveys in the next few weeks.
Tell us about your engagements with Shell beforehand, and why did the 2 parties not come to a similar understanding of the process?
Certainly, Shell's lawyers were approached initially through their environmental consultant who had put out the notification of the seismic surveys. We requested certain information, and it's very difficult to take action when there's no information available. So this information was requested numerous times from the consultant. It was not provided. It was referred then to Shell's lawyers. The information was again not provided. As you would have heard in the judgment as well, Shell refused to give an undertaking that they would not commence with the seismic surveys pending the outcome of any challenge to it. And as a consequence, the application had to be brought on what we call a hyper-urgent basis.
We've just spoken to the SA country chair, Hloniphizwe Mtolo. Ironically, his name means looking after the environment. And he asserts that it's not the first time that Shell has conducted such activities, and they have not proven to be dangerous against the environment. What is the basis of your argument?
Counsel made a good point. There's a big difference between an absence of evidence and an evidence of absence. And there's a growing body of evidence, in fact, that there are impacts on a variety of different marine organisms and the environment in general. So in this case, we had anticipated a return date where we would be provided with an opportunity to provide that expert evidence. But given the hyper-urgent application that had to be made, it was literally within a few days. That evidence was not, fully before the court in this particular application. But we are disappointed that we weren't provided with an opportunity to provide the court with that evidence.
Melissa Groenink is a program manager for Natural Justice, and giving us their reaction to that court decision regarding the Shell exploration efforts. And that's a wrap of the show.